Good evening, ladies and gentlemen, and over to our secretary for the initial remarks and kindly open the session. Shritar, please.
Respected Chairman, Godavarti Srinivasarao, today's resource person, Sri L. Jayaraman Sir, Managing Committee members and fellow members, good evening to one and all. I welcome you all for the third day of virtual series of CPE programs and the Companies Act 2013, Part 2 for the subject Private Limited Companies. I hope yesterday you had a fantastic session on the topic directors and various resolutions to be placed. Today also we are going to deal with directors and related topics, manager remuneration and related party transactions and inspection and investigation, etc. Thank you. And I request Jayaraman sir to move on to the session. Thank you.
Over to Jayaraman sir for your this thing.
Thank you. So, good evening, my dear participants, my dear delegates. Thank you, Srinivasarao Garu and Shireen. Continuing the discussion what I had yesterday, we will look into duties of director. This is a new section which has been introduced in the Companies Act in the Companies Act 2013. Very interesting point. And if you don't follow, it is punishable. A director should act in accordance with the articles. In other words, ignorance of law is no excuse. You are supposed to read the complete articles, understand, and follow the provisions of the articles. And your management as a part of the board of directors shall be strictly as per the articles of association of the company. Next, the director of a company shall act in good faith to promote the company's object and benefit of the members as a whole, in the best interest of the company, employees, shareholders, and community, and for the protection of environment. Very important point as such. Now, social responsibilities of business. In sole proprietorship and partnership, my only object is to earn profit, and profit alone. As a business enterprise, I have no other objective except earning profits. But in the company form of organization, there is something called social responsibility of the directors, social responsibility of business. So often, when you are sitting in the board of directors, there's a confusion. When I take some decision, it may be in the best interest of the company, but may not be in the best interest of shareholders, vice versa. Sometimes some decisions, if I take in the interest of the workers, for example, I'm looking from the workers' angle, that is, I want to take more safety measures, more welfare measures, give them reasonable salaries, comply with all the labor legislation, obviously at whose cost? At the cost of the company and indirectly at the cost of shareholders. Now comes the conflict of interest. Next, is there any responsibility towards the customers? Yes, gone are the days that whatever I produce will be sold in the market. My responsibility towards customers, who will survive in the market today? The three mantras of marketing: qualitative goods, reasonable price, establish the brand image. Then only I can successfully satisfy the customer. But then quality, reasonable price, brand image means lower profits. Then responsibility towards society. Business cannot live in isolation. I have to sponsor a lot of sports programs, lot of cultural programs, this, that, and all. Then this story goes on. There is an answer here. So when I'm sitting in the board of directors, my responsibility towards the members alone is not the end of the story. I'm also responsible for the members. You know, what my responsibility is limited towards the members. What is my responsibility towards the members? Earning good profits, paying good dividends, giving them right shares, bonus shares, ensuring good market price of shares, attending to investor grievances and all. That's only one small part of the story. And this is the great answer here. He says, you shall function keeping all the company's objects as a whole. So from the company's angle, you think, also keeping into account the benefit of the members as a whole. And it didn't stop there. And you also take into account the interest of the employees, shareholders, community, and protection of environment. Greatest answer is available here. So therefore, business today means business and ethics. It is not business or ethics. You do business with ethics. That is what the answer is here. So many of the sole proprietorship partnership, they may not be interested in the corporate form of organization because of this. But here was slight thinking. The mindset has to change. The corporates have come to live for hundreds of years. After all, the profits are earned not only because of the shareholders, it's earned because of the employees, their contribution, their sweat and blood which they have spent. And also, so you have to do some kind of balancing somewhere. So the answer is given. You're thinking, no doubt, you have to keep the company's object in mind, shareholders in mind. You also take into account the welfare of the employees, the interest of the customers, the interest of the community, the interest of the society, and also environmental interest. You have to comply with the air pollution, water pollution, environmental protection, all that. The answer is here. Third, a director is expected to perform the duties with due care, skill, and diligence. As I already discussed, a director need not have any specific qualifications unless he is an independent director now, which obviously will not apply here. So now the question is, a director, as soon as he becomes the director, is he required to take some training, attend some course, or improve his professional knowledge and all? Not at all. What is the level of care which the director has to take? Reasonable care, skill, and diligence. I'm not expecting any extraordinary performance from the director. He should take that level of responsibility based on his qualification, experience, and all that. Reasonable care. He should behave like a man of ordinary prudence, not any kind of extraordinary care, and exercise independent judgment. Suppose he is only become qualified, he may take only one level of when it comes to certain decisions on financial things and all that. Suppose if you are a chartered accountant, definitely the society expects a higher level of care from you, skill and diligence. So, beautiful sentence that you shall function as per your ability, based on your experience, qualifications, and all that. And you shall exercise independent judgment. Next, you should not involve in a situation which will have direct and indirect interest that conflicts with the interest of the company. And together with this, a director should not attempt to achieve unduly gain advantage for himself, relatives, partners, associates, and all. A director occupies in fiduciary capacity. Fiduciary capacity means when there's a conflict of interest, personal interest and official interest, obviously his official interest must prevail over the personal interest. You are a trustee. You are like a trustee of the shareholders. So therefore, keep all your personal interest aside. Even though there are certain sections where the director can enter into contracts with the company, which we'll be discussing in the next 2 days, like loans to directors and others, related party transaction, disclosure of interest, all that. There is already a regulatory mechanism in the Companies Act. So you comply with that and go ahead. But then it's a general statement. Don't give any kind of advantage to the relatives and all. You trying to misuse the power and position of the company and try to help them at the cost of the company. That is the idea. I'll put it very bluntly. In one of the private company, MD's wife, a 7th class dropout, she was appointed as HRD consultant on a salary of just 1,50,000 per month. लूट लो भाई, company में जितना भी पैसा है ना लूट लेना. So these are all the areas which he is talking. Don't give the dealership, distributionship, and all other advantages because of you misusing the power to your relatives, associate partners, and other people. You exercise your independent judgment, but then there are safeguarding provisions in the Companies Act, which we'll see all that later. So it's only a general statement. Keep in mind, you shall function like a judge. You should not, you should use your independent judgment. You should not show any kind of favoritism towards anyone. Next, the director should not assign the office. An assignment is void. You should have read in the Contract Act, assignment of public officers is void. Say for the fun of it, President COVID cannot sell the office of President of India to Musharraf for 50 crores. Office of President of India is not your personal property. If you want to become the president, okay, you cannot appoint your brother or someone. So that's a public office. So transfer of public offices is void. Please see, the office of partnership is a transferable office. With the consent of the other partners, you can sell the office of partnership. The office of shareholder is a transferable office. You can sell the shares to others. But the office of director is not assignable. You cannot delegate the office of director to your brother or someone. If you want, you become the director. Otherwise, resign and get lost. So this office cannot be assigned. If you assigning means transferring the office to some person with or without consultation. All that is void. And this was introduced, and they made an attempt to bring some duties and responsibilities for the director of the company. And very interesting point is, they also said, if you violate this, punishment minimum 1 lakh, which may extend to 5 lakhs. So duties of director. So I just briefly told you. Moving on, liabilities of director. Now, yeah, I'm not talking of managing director, whole-time director, and all that. I'm only talking of ordinary directors who come and attend the board meeting. They are not in charge of day-to-day affairs. So therefore, this is a separate section which says independent director, non-executive director, not being a promoter or KMP, you are only additional director, you have no connection with the management, shall be liable only for the acts of omission which has occurred through broad process or with the consent or connivance, or he has not acted diligently. Very interesting point. In Satyam Computers, though it's a public company, listed company, how did all other directors escape? You mean to say other directors are no responsibility? Only the Ramlinga Raju, the managing director, and some full-time directors are responsible? Can these other directors go scotch-free? Let us make a very reasonable approach. Those points which come to the knowledge and notice of the directors, as per law or otherwise, and if they are negligent on that, they should be made liable. So other things which cannot come to the knowledge, some fraud which has occurred somewhere internally, you punishing the director, ordinary directors, doesn't make any sense whatsoever. You punish the managing director, that is something different. So what is he saying? The ordinary directors will be liable only which has come through the board process. If they are negligent in taking a particular decision which comes to the board, for that only they will be liable. Then directors KYC. This is very important. Now you know every director has been allotted DIN number, director's identification number. Now the requirement is every financial year, changes you are to file. If there are no changes also, you are to file with ROC as on 31st March of the financial year. Normally, you should file it within 30th April. But this year, because of COVID, they have extended this facility up to 31st December 2020. I repeat again, regarding DIN, you have to update. Suppose the passport number is changed, or you renew the passport, or change the address, or some details. Now, whatever details are there, you should file with ROC. So if you don't file, the consequences will be severe. So directors KYC. Now, one more thing, you are all aware that one-time form has to be filed with ROC by every company. That is called e-form active form. E-form active form. This form has to be filed only once. Those who have already filed it, fine. Those who have not filed it, please file it before 31st December, taking advantage of this company law scheme. Now, before filing that e-form active, it will ask you a lot of details, like you should have appointed company secretary. If you are required to appoint, you should have filed all the documents relating to auditors. Then you should have filed financial statements and annual returns, annual filings you should have completed. And there are certain requirements. So all that, if you comply, it's only to tell the government that if you have filed the e-form active, if it is accepted, your filings are updated. With that intention, they introduced that e-form active. Now, in that e-form active, if your DIN is not updated, it will write there as active non-compliant. Director active non-compliant. So you have to be very careful. Otherwise, what happens? Your DIN will become deactivated thereof. So please ensure that your directors, every year you file this DIN has to be updated, director KYC you have to file, and this please ensure. Otherwise, hell a lot of problems are there. You cannot file any document at the ROC on behalf of the company. So this DIN has to be, this director KYC has to be filed every year, and this year we have time, so please file it. Similarly, one-time return like e-form active has to be filed by the company concerned. So if you have not filed it, you please file it before 31st December of this year. Then we will now move on to the next topic of discussion, board meetings. And with reference to private company will be my focus of discussions. We are talking of minimum board meetings. The first board meeting must be held within 30 days of incorporation. And thereafter, you must hold minimum 4 board meetings the calendar year, January to December, not financial year. In such a manner, the gap should not exceed 120 days. In other words, if you have held the board meeting on 1st January, the next board meeting must be held somewhere by before 30th April and all that, so that it should not exceed 120 days. Now, why the first board meeting within 30 days? This is a new provision. Because the company is just incorporated, you know, the directors have to meet and take stock of the situations. They have to look into the memorandum articles. They have to decide the preliminary expenses. They have to open a bank account. They have to print the share certificates. They have to decide the future projects. They have to recruit some employees. So a lot of things. So company cannot go on like that. So the first board meeting must be held within 30 days. Fair enough. Today, holding a board meeting is so costly. Of course, now that you can hold the board meeting through video conference, the cost has come down tremendously. But holding video conference by private companies, it's not compulsory for them. So the Act only talks of minimum board meetings, which you have to hold it. Now, if it's a small company, the other day we discussed that once in 6 months, if you hold, that is enough. Then, while calculating these dates, the meeting may be adjourned. So we have nothing to do with the adjourned meeting. For example, calculating this 120 days and all, from the date of original meeting only, that 120 days and all will be calculated. Then this section talks of only minimum board meetings. You can hold any number of meetings. It shouldn't be less than this, what has been prescribed. Then length of notice, small issues. The first and foremost point is, when it comes to general meeting, the Act is very particular about small issues like 21 days notice you must give, how the notice has to be spent, what are the contents of notice, who are the persons entitled to notice. Minute points they are given in the Act itself. But whereas when it comes to board meeting, they lack the thought not to interfere. We will leave it there. We will leave it to the articles. Let the directors themselves decide. Let the framers of the company, let them decide in the articles. So, but here secretarial standards have come now. Secretarial standards, the other day I told you SS1, SS2 are compulsory, and lot of answers are given in the secretarial standards, which applies even to private company, and you have to follow all this. These are all, if you don't follow secretarial standards, also punishable, just like accounting standards not followed, punishable, like that here also. Of course, you can write something different in your articles, then the secretarial standards and all not prevail. In a situation where nothing is given in the act, nothing is given in your articles, then these things you have to follow. You should give at least 7 days notice, fair enough. The directors are all busy people. You just cannot convene a meeting and tell them, please come tomorrow or day after tomorrow. So therefore, 1 week notice makes a lot of sense. Then how do you send the notice? In case of general meeting, if you send by ordinary post, also fine. Now, no ordinary post for directors. You cannot insult the directors like that. So they are very clear. You should send by hand delivery if possible. Generally, it is a good ethics that if the registered office and the director stays within the same city, and you must send the office boy or someone and physically deliver the notice. That is only ethics. Okay, you send it by hand or speed post, registered post or courier. Don't send it by ordinary post. Then facsimile, fax or email, electronic means also is now permitted. Then these are some secretarial standards. In fact, I told you, I was in the secretarial standards board at Delhi 3 years back. And during my period only, the secretarial standards were finalized. So we had almost 18 to 20 meetings, each meeting running for 3 hours, 4 hours. It was a 32-member body. Wonderful people. It was a fantastic experience, highly qualified professionals there. So many issues we discussed and finalized all this. Now, where we should send the notice? To the registered address with the company. Registered by the company. That means, suppose I normally take classes in at various places in India. I'm a director of a company. Then I told them, say in the month of December, if you are conducting any board meeting, I will be in Chennai. Please send the notice to this address. Where do they send? To Chennai address only. Wherever, if I'm told. If I'm not told, then you send it to the address, whatever I given to the company. If no specification I have given, then the DIN in the director's identification number there, whatever address is there, you please send it. That is enough. That is sufficient compliance. Then, when a director specified a means of notice, you must give. After all, there is 12 directors. Some directors said, no, please don't send by speed post. The post office fellow will come and go back. I am not there. My wife is also employed. So you send it only by courier. In courier, at least he will telephone me. So there are some advantages like this. You send like that only. Sometimes if they say, please send by email. So you have to send only by that method. If you are sending by post, 7 days plus 2 days, 48 hours, you must allow. Then a director who is abroad, you must send a notice to his address abroad. These are all the new points. In the earlier Companies Act, if you send it to address in India, that is sufficient. Now it's not there. But general meeting notice, you can send it to an NRI person to the address in India. For director, you must send it to abroad. But anyway, these are not big discussion as such because now email has come. So if you just put it wherever is there in the world, you can have access for that. Next. Then notice to which director? Every director. Whether he's interested director, of course, in private company, interested directors can also vote, doesn't matter. Whether he's interested, whether he's an original director, whether he's an alternate director, for both you have to send the notice. Alternate director, anyhow you have to send. Why the original director? Maybe he may come back to India to attend the meeting. So notice must be given to every director, no exception to that. No waiver of notice. So these are all practical case laws. Even when a director tells you that, next board meeting, oh, I think you are holding in December. In December, I'm abroad here. He may say. Now, the company secretary can prove that the director has specifically told that he will not be in India. But still, should I send notice? Yes, yes, and yes. Notice of the meeting is one issue. Attending the meeting is another issue. There's no correlation. Don't combine both. So no waiver of notice. Shorter notice can you give? Yes, there could be some urgent requirements. There should be some calamity in the factory where within 2 days the board has to meet. Fine. What is urgent business? The chairman will decide. So you can give 1 day's notice, 2 days notice, or you can give notice in the morning and call for the meeting in the evening. What is urgent business? Leave it on the chairman. So for shorter notice is permitted. Then what happens if you don't give notice of the meeting? The officer in default punishment 25,000. That is only a small issue. But look at the other two consequences. In general meeting, accidental omission to give notice or non-receipt thereof will not invalidate the proceedings. That point is not there in case of board meeting. In case of board meeting, one director, if he has not received the notice and he can prove, he can take the whole meeting into ransom. He can go to the court and get the proceedings invalidated and declare the resolutions as void. The logic is very simple. After all, there is 12 to 15 directors and the company cannot take care to send proper notice to all the people. So no question of accidental omission and all. Notice must be given to all the directors in the manner specified in the act as such. Next, ratification. There are some case laws which says, okay, sometimes it so happens a director did not receive notice, but then the telephonic and other communications are there. It was told to the director, sorry sir, please come to the meeting. And the director came to the meeting. I'm not justifying this, but since the director has come to the meeting, he will lose his right to get the meeting invalidated. So that's called ratification. But if he comes to the meeting and shouts that I have not received the notice and goes away, that is not ratification. The director comes to a meeting, sits there, participates, takes the sitting fees, then definitely his right to get it invalidated is gone. Ratification can be done. Then concept of continuous notice. This has been recognized by the case laws. What is this continuous notice? Please see. In certain professional companies, multinationals and all, what they do, they predetermine the dates of the board meeting. For example, I may amend the articles and write in the articles, or in one of the board resolutions, I may say, henceforth, the board meetings of the company will be held on in the month of February, April, and July, and November, something like that, on second Monday of that month at 11 a.m. at the registered office of the company. Predetermine the dates of board meeting. Then if you predetermine the date of board meeting and the company secretary at least once, he has to send to every director the copy of the articles or copy of the board resolution, inviting his attention to that particular article. Then thereafter, for every board meeting, he will send the notice. That itself will act as a concept of continuous notice. Of course, as a courtesy, he may telephone and tell. And the courts have accepted this concept of notice. But then secretarial standard, we did not agree. But so just conflicting things are there. We'll see when the matter goes to court. Let us see what new decisions they say. Because secretarial standards, we talked of better corporate governance. So even if the meetings are on predetermined dates and predetermined intervals, you are to send the notice. Because notice will contain agenda and other agenda notes and all that. Then notice for adjourned meeting. The act is silent. The act doesn't provide for notice for adjourned meeting, board meeting. Nothing is there. So articles also, if you want, you can write something. But the secretarial standard says notice for adjourned meeting also must be given. Even though no new business are discussed, you must give adjourned meeting also 7 days before the meeting. And you must give it to all the persons, those who attended the original meeting, those who did not attend the original meeting also, you must give the notice. Contents of notice. See, very simple. As I told you, the act did not concentrate on small issues. They are not bothered. So they say table F you write. Otherwise, in your articles you write contents of notice. For the fun of it, suppose the articles are silent. Come on. Can you, company secretary, send a notice? Please attend the board meeting. For details, contact company secretary. You lose your job. But surprisingly, This is very much a notice under the Act. But anyway, good secretarial practice demands what you should say, serial number of the board meeting. Now, this is very important. Now, people are inserting lot of bogus minutes and all inside. So, we want a serial number, 132nd, 133rd board meeting right from inception, or year-wise you maintain serial. Day, date, the time and address of the venue, all that you have to specify. Not only that, agenda and agenda notes also has to be given 7 days before the meeting. Not that you will send the notice and just 1 day before give the agenda. See, what is the idea in giving agenda? Directors can prepare and come. Agenda notes also, instead of wasting the time there, the background of the discussion also will be given to them. So they can only, if the doubts are there, they can exchange. So that each and every item, they can just finish off in 3 minutes, 4 minutes, and if required only for longer period of time. So good secretarial practice requires agenda must be sent, agenda notes also must be sent 7 days before the meeting. Then, very interesting point in secretarial standards which have been covered. Now, what sometimes it so happens, I want to discuss one item which was not given in the agenda. Maybe all of a sudden, it came out of the discussion, or maybe urgently the company secretary came to know about 1 day before the meeting. Can you discuss those items? Please remember, in general meetings you cannot, because notice as required under the Act must be given. All of a sudden you cannot put up any new ideas in general meeting unless it is a special notice. Right. Coming back to the board meeting, he says, okay, fine. If an item of agenda is not included, last minute you can include. What is the problem? The directors who did not attend the meeting, they are losing. They may tomorrow complain. Had I known that this item is being discussed, I would have definitely attended the meeting. Anyway, the secretarial standards very clearly says, okay, depending on the urgency, the chairman may take up that agenda for discussion, even though not given in the notice, with the consent of majority of directors present. Which, when they feel that this item cannot wait till the next board meeting, you can go ahead with that. So a lot of safeguards accordingly is being taken. Who can convene the board meeting? These are small issues, back to basics. Let us spend some time, realize all this. Let us look into all these points. Now, who can convene the board meeting? Act is silent. Table F model article says, any director may, look at the fun. Don't be under impression only chairman or managing director. Any director can convene the meeting. And what about the manager as defined in the Companies Act? What about the company secretary? On his own, he cannot convene, but on the requisition of the director, the secretary himself can send the meeting. This is what is given in table F. My advice will be, this is very, very difficult. Well, I'm not saying that we should not give a right to every director, but there's something called protocol, ethics and all that. So you can write your own articles, some alternate provisions like chairman will convene the meeting, vice chairman, or secretary in the absence with the consent of chairman, something like that. That will be a better proposition. This issue was discussed in the Secretarial Standards Board, and finally we came to a conclusion that if the articles are also silent, this is the rule we said. Okay, any director may summon the meeting because we cannot go contrary to the table F in the absence of specific articles by the company. So what we said is, fine, any director, company secretary, also if there is no company secretary, on the requisition of the director shall convene the meeting. Then we have added, in consultation with the chairman, MD or whole-time director. Because why we said, sometimes what happens, this company secretary does some overaction. Even though company secretary is a very important person, you are practically, you are subordinate to the chairman and managing director. You must give respect to them. You cannot equate yourself to a board, though in certain sections you are reportable to board. The context and circumstance is different. Therefore, what we did in secretarial practice, yes, one director has asked to convene a meeting, talk to the MD, talk to the chairman. You can't take your own decision like this. So in consultation with the chairman, if he's not their MD, full-time director, then only you convene the meeting. Place, time and date of board meeting. Act is silent. Table is also silent. So if you want to write something, table F is silent. If you want to write something in your articles, but then in the absence of anything you write in the articles also, then now where you can hold the meeting, any place convenient to the directors. Can you, if the registered office is in Hyderabad, can you hold the board meeting in Lalu Prasad Yadav's house? The law is silent, but then 2 points you must keep in mind. You can hold the board meeting at any place in India or even abroad if the circumstances justify and no malafide intentions involved. Even though you're not violated in law, anyone can go to court and say, sir, I am a director staying in Hyderabad. Registered office is in Hyderabad. They are trying to hold the board meeting in Kashmir. And another point is, the Kashmir is in trouble today. Just say, for example, then let us say the sitting fees is not, the expense for traveling is not, and COVID situation is there. So the idea is they don't want us to attend the meeting. Court will interfere. So keep in mind, even though freedom is given, this is not an absolute freedom. The conditional freedom is you can hold at any place, even in foreign country, if the circumstance justify. For example, if there are 12 directors and 8 directors are abroad and companies were 4 in India, then instead of asking them to come here, you can ask these 4 people to go there. At least they can see you as that company's expense. Oh, no, don't look at it from that angle. And there is no malafide intention. These 2, then you can hold at any place in India. Then you can hold on national holiday also, no restrictions, Sunday, festival holidays, national holidays, and any business you can hold even nighttime, daytime, anytime. But good commercial practices you must follow. My experience is so bad that normally, please don't hold the board meeting during nighttime. Very unfortunately, let me bluntly tell you, 99% of the directors in India, I'm qualifying that, are alcoholics. And they take, and 9 o'clock, the board meeting starts wonderfully. Discussion after discussion will go. The board meeting will go up to 2 o'clock, 3 o'clock in the morning. And they discuss loans to directors, related party transaction, disclosure of interest, wonderful things they will discuss. And the next day, they will deny having attended the board meeting. See, please attend. You are a director. You are taking decisions abroad and all, even though everyone is alcoholic, but there's a time for them to drink. I've been in US for 3 months. I've attended 3 board meetings there. There, if no one who daytime takes alcohol there. In fact, in one board meeting, I told in India, please don't consume alcohol because certain collaboration decisions are to be taken, and 2 foreign collaborators agreed with that. So anyway, it's a passing reference. You please don't hold the board meeting during night time and things like that. Next, informality in the board meeting. See, let me tell you practically, except for few private companies, practically where you hold the board meeting, it is called kitchen meeting. The wife of the director dictates something and the company secretary writes the kitchen meetings, we call it. Anyway, in some cases, there will be a board meeting in private company also, right? Since the institution nominee may not be there and certain important people may not be there, it is only family members are there, they will fight in the board meeting also. For example, the father-in-law may start, today sambar was not at all tasty. Then daughter-in-law will start, is it board meeting or sambar meeting? Then the fight starts. Certain things will be discussed. Then it goes on. In the meantime, you discuss something, then they will adjourn the meeting. When did the board meeting start? Is it a board meeting for the purpose of Companies Act? A mere informality will not be sufficient to invalidate. So is it a board meeting? Did the directors meet just like that or in pursuance to a notice they met? Yes, sir, they met in pursuance to the notice. Where their quorum? Fine. A sense of informality may be there, but that is not enough to invalidate the proceedings. Then comes video conferencing board meetings is now allowed, right? Most of the companies are allowing it, but private companies are also allowing it, but you cannot force. It's for public company, it is compulsory. But then There are certain restrictions in video conference board meeting. If you participate through video conference, your presence will be counted for quorum. Your voting also is valid. You can take part in the proceedings. But these 4 cases, approval of financial statements cannot be done through video conferencing, approval of board report, approval of prospectus, audit committee meetings for a consideration of financial statement, approvals regarding amalgamation, merger, demerger and all. Anyway, some stupid fellow in the department has drafted all this. All right, today technology has changed so much. So what? If some figures are involved and all, you can just show the figures and participate. Anyway, let us leave it there. But there is a small clarification now. Even though for these 5 items, if the physical board meetings must be held, and if the physical board meeting quorum is present, some of the directors can participate through video conferencing. That small clarification they have said. Not that you cannot participate at all, but the rider is in these 5 cases, hold the physical board meeting and the quorum should be there physically. Then some of the directors can participate through video conference and all that. Then what is the quorum for the board meeting? I am restricting my discussion only to private company. 1/3 or 2, whichever is higher. But then I have a very interesting feeling here. Suppose there are 12 directors. 1/3 is how much? 4. 1/3 is 4. 4 or 2, whichever is higher. 4 is fine. In fact, you can provide a higher quorum also. See, invariably what happens? You force the directors to come to the meeting. After all, the directors are the representative of shareholders. You must get time. You must attend the meeting. Keeping a lower quorum is not correct. Anyway, now if you participate through video conferencing and all, you will be counted for the purpose of quorum. Now, fraction shall be rounded off as 1. Now, look at this table quickly. Suppose the total number of directors. If it is 12, quorum is 1/3 is 4. Now, if it is 11 also, it comes to 3.674. 10 also, 3.33, it comes to 4. So, no mathematical rule. Any fraction shall be rounded off to the next number, not to the nearest number. So, 983 will be 3 directors, 654 will be 2. 3 and 2 also minimum 2, because one fellow cannot talk to himself. So these are all the quorum. Then can the articles provide for larger quorum? Even though the Act doesn't specifically tell that, you can provide for the larger quorum. In fact, that is better. More than 1/3 also can provide. You can say majority should come. That is good secretarial practice. When quorum should be present? When quorum should be present? Very interesting point. In general meeting, the quorum must be present when the business starts. But whereas in case of board meeting, the quorum should be present throughout the meeting for every item of business. Even though interested directors and all are allowed to vote, quorum should be present for every item of business, not just for the commencement of the meeting. Then, presumption of quorum. See, not that we'll be counting, every chairman will count for every item, quorum is there, quorum is there. No, not that. He will presume that quorum is there, unless someone has pointed out there is no quorum at all there. So quorum will not be practically counted. Same quorum for the adjourned meeting. No concessional quorum. In case of general meeting, we had concessional quorum, but in board meeting, it's no concessional quorum. Come on, you must attend. In the secretarial standards, what we said, okay, there was no quorum. Again, the meeting was adjourned next week. In the next week also, if the quorum is not there, meeting stands cancelled. It's a good secretarial practice. Again and again, we cannot adjourn. Now, no quorum at a board meeting is a very, very great offense. Chairman will not take it very easy. After all, we have consulted you directly or indirectly and kept the board meeting. Okay, one time some extraordinary circumstance can happen, so they have adjourned the meeting. In the adjourned meeting, you must come. So therefore, no question of adjournment again and again. So first time when you adjourn, when there's no quorum, again quorum is not present, meeting is cancelled. It is not a meeting at all as per the provisions of the Companies Act. Right. How long I should wait for quorum? In general meeting, I should wait for 15 minutes, half an hour. Here you wait for 15 minutes unless the articles otherwise provide. The meeting stands automatically adjourned. Same time, same place, next week. Automatically. If the day is a national holiday to next day, which is not a national holiday. Because earlier, this next day, because earlier Sunday is public holiday, they said. So original meeting held on public holiday, Sundays people have not come, again it will be adjourned to Sunday. But the stupid fellow again he said national holiday. Anyway, leave it there. Now my point is, unless the articles otherwise provide, I request all the chartered accountants, please advise the clients to amend their articles. If the quorum is not there, let them convene the meeting the next day or 2 days. You write something in the articles like that. Why should you wait for 1 week and all that? Anyway, this, if you don't write anything in the articles, automatically it stands adjourned. Same day, same place, same time, next week. If it is a national holiday, the next day. Now look at the fun. Just now we discussed original board meeting can be held on national holiday, but adjourned board meeting, adjourned for want of quorum, cannot be held on national holiday. Don't ask me the logic. It is illogical. Anyway, leave it there. Then resolution by circulation. Now, board can take decisions by two methods. One is at the meeting of the board. The second is resolution by circulation. In meeting of the board, the directors sit across the table, exchange the views and ideas, and take a final decision. So, well participated, healthy decisions is possible. I may come out with a negative mindset when I attended the meeting, but thereafter, as in one, thereafter when I sat in the meeting, looking at the point of view of the other directors, I do change my opinion. So effective board meeting is through physical board meeting or even video conference. In resolution by circulation, what happens? The directors sitting in their house will take a decision on their own. Now, resolution by circulation has to be understood very carefully. Each and every word makes the department. No resolution is deemed to be passed by the board or committee by circulation. That means what? No resolution deemed to be passed. The requirements of this section has to be fulfilled. One, the resolution in draft together with the necessary papers have been sent to all the directors. Look at small issues. Just like that, you pass is not a resolution. The requirements of this act has to be complied with. First one, he says the draft resolution. We in board meeting, we said only agenda will be sent. The draft will be made there. But here, what is that exact resolution you are going to pass? Word to word, you must send it to. For example, you are appointing some additional director. Resolve that pursuant to section so-and-so of the Companies Act, Mr. L. Jayaraman, B and D hereby appointed as additional director to hold office up to the commencement of the next annual general meeting of the company. Then so-and-so person. Like that, the entire draft has to be sent to all the directors together with the necessary papers. What is necessary papers? Such necessary papers so as to enable them to involve themselves in informed decision-making process. Send it to all the directors. If it is committee, send all to the committee members. The story is not over. Where I will send? To their addresses in India. I think it's mostly a mistake they made. Anyway, in law, we cannot presume mistakes. So what about the directors outside India? You don't have to send those notices to them in resolution by circulation. How do you send? By hand delivery, post, courier, email, and approved by the majority of directors, who are entitled to vote on them. Here the majority is different. Whereas in case of board meeting, number of votes in favor, more than number of votes against. But here, majority of the directors, all the directors, suppose there are 12 directors, 7 has to vote in favor. And who are entitled to vote. If interested director will not be allowed to vote. Anyway, in a private company, there's no problem. Interested director can also vote. So if all these requirements are fulfilled, then only it is called resolution by circulation. Now, one more amendment they made. As I already told you, in resolution by circulation, there's something lacking. So 1/3 of the directors 1/3 of the directors in the next board meeting, they decide. 1/3 of the directors, what they decide? 1/3? No. This resolution which was passed by circulation should be put up to the board. Then you are to put up to the board. And it is final only when the board meeting passes the resolution by circulation. Recording the minutes, these provisions were not there earlier. Now they made it very clear. So you don't have to make it a part of the minutes of the next board meeting. So some of the chartered accountants, company secretaries, they write in the minutes that resolution passed on so-and-so date. Not required. Last board meeting, and after that resolution was passed by circulation, and this resolution should be recorded in the next minutes board meeting as if it was passed on so-and-so date. Then vote of alternate director. Yesterday also I discussed this point. In a scenario where alternate director, original director is also participating through a post, the vote of alternate director only will be considered. Then authority to decide. These are told in secretarial standards. Now, who will decide that this particular item is very urgent? We cannot wait till the next board meeting. It should be done by resolution, by circulation. There should be someone to take a decision. Chairman will decide. If he's not there, MD. If not there, whole-time director. Or any director who is other than interested director should decide whether it should go through board meeting or resolution by circulation. Fair enough. Then, chairman of the board. Chairman, just like notice is essential, just like quorum is essential, these are essentials of meeting, there must be chairman. Generally, what happens, there will be a permanent chairman in the company. One of the directors will be appointed as permanent chairman, he will chair. Next, if there is no such permanent chairman, or chairman is not present within 5 minutes, in general meeting, 15 minutes, chairman is not present within 5 minutes, but present unwilling to act, what happened? Throat problem. Then why did you come? Only for masala dosa and other things which are given the board meeting, he came. Anyway, leave it. So, chairman is not present within 5 minutes or present unwilling to act. One of the directors will be elected as chairman and he will proceed with the meeting. Some secretarial standards on minutes of the board meeting. On the day itself, I discussed about minutes which will apply for both the general meeting as well as board meeting. Some issues. As per the act there, the other day we discussed, minutes should be in separate books kept for the purpose. The language implies that you have to write the minutes by hand, idiotic and senseless. In this technology age, how will you spend your time and write by hand? So now the department has come out with the answer. You can take computer printout and loosely binders you can keep, but they are to be bound at periodical intervals. Once in a year, you bind it, minutes book 1, minutes book 2 and all, then you can keep in loosely binders. Finalization of minutes, these are new points they have added now. Minutes has to be written within 30 days, but now the next extra point in secretarial standards is within 15 days, you prepare the draft minutes and circulate by hand, speed post and all, or electronic means to all the directors in the committees so that they can give their comments. After all, whatever decided by the chairman is final. There's no doubt on that. But still, let the directors make their representation. So this is told in secretarial standards. Minutes cannot be altered. Some spelling mistake, you can correct it, but beyond that, nothing. So if you want to alter in the subsequent meeting, you must pass a new resolution. That is the only method by which minutes can be altered, not otherwise. Then inspection and extract of minutes. These are all secretarial standards. For example, let us see one by one. Minutes of the meeting of the board or committee can be inspected by the directors. Fine, members cannot inspect because they are confidential documents. A director is entitled to inspect the minutes held before the period. Very interesting. I am responsible for the second and third points in the Secretarial Standards Board. A discussion came. The company is about 25 years old company. A person was appointed as director 3 years back. The director wants to see the minutes from the inception. Some of them objected, no, you can inspect the minutes during the time in which you are a director. I said, why? I would like to know the policies of the company. What is the mindset of the business? So what is wrong if you allow him to inspect the minutes for the last 25 years? Nothing wrong. So finally they agreed. So you can inspect before the period of directorship also. Now one more issue arises. A director ceased to be a director. Now he wants to come and inspect the minutes during the period in which he was a director. He was a director from, let us say, 2017 to 2020. Then he resigned. Afterwards, he wants to inspect. Okay, you inspect during the period in which you are a director. What decisions were taken? He was sued in a court of law. That is all permitted. Then, in fact, I walked out on this. The company secretary in practice appointed by the company secretarial auditor can also inspect the minutes. This one. Inspection can be provided in physical form or electronic form. And this is where my objection was. While providing inspection, the company secretary or official authorized by the companies to facilitate inspection should take all precautions to ensure minutes book is not mutilated or tampered. I said, this is too much, isn't it? Suppose the director tears the minutes and company secretary is responsible. I just shouted and others did not agree. I said, practically you draft a rule here. When you're drafting a rule, will I sit very close to the director? Now COVID is there, I cannot go near him also. And if he touches it, hey, don't touch it. When you make a rule, practically how it is to be implemented, everywhere company secretary is responsible. Janmantra papi, come on, that's all what to do. So while providing the inspection, the company and official should take all reasonable precautions. It all reasonableness only, leave it there. Then minutes of the board meeting is a confidential document. Members cannot inspect. Extract of minutes can you give? Sometimes it so happens that board has taken a decision, we have to give it outside to open a bank account, something like that. Then the rule is, before you have to write the minutes in the book, then only take the extract. Even if it is signed, not signed, no big deal. It can be signed in the next board meeting also. Next section. Defects in appointment shall not invalidate the actions. Section 176. See, this is in correlation with the doctrine of indoor management. A director has acted on behalf of the company. It could happen the director was disqualified, but he is acting as a director, or he is terminated, still is acting as a director, or there's a defect in appointment, he is acting as a director. How will the outsider know? So the law says, any acts done by a director shall not be invalid. That means shall be valid, even though it was discovered later on, the appointment was invalid, or there was a defect or disqualification or terminated. And that the company is not aware, the director also is not aware. He acted, then the company will take the responsibility. But once the company or director comes to know, still he is representing the outsider is protected in both situations. So once the company comes to know, or the director comes to know of the defect, disqualification and all that, still he acts on behalf of the company. Director will be personally liable, company will not take the responsibility. Then I'll spend some time. Division of powers between board and shareholders. We must understand this. What did we read at our inter-level? First, the Companies Act talks of two-tier management. Some powers are vested with the board of directors, some powers are vested with the members. They are not interchangeable powers. Please understand. Shareholders' powers cannot be exercised by the board, board powers cannot be exercised by shareholders. Who is supreme? Don't enter into argument. Board has got their own powers, shareholders have got their own powers. What are the powers of the shareholders? They are only peripheral powers. Approval of financial statement, declaration of dividend, appointment of directors, removal of directors, auditors, then buyback of shares, sweat equity shares, amendment of articles. They are all boundary powers, peripheral powers. Real power is concentrated with whom? Collectively, the 12 people board of directors. Hundreds and thousands of crores of rupees of fixed asset under their control and custody. They have managerial powers, they have administrative powers, they have purchase powers, sales powers, recruitment powers, dismissal powers, whatnot. So let us say two-tier management. Board powers are different, shareholders' powers are different, and they are not interchangeable powers. And once the shareholders have given the powers to the board, come on, shareholders cannot interfere. This is the presumption under which we will enter. Now the section says, the board shall be entitled to exercise all such powers, do all such acts and things as the company is authorized to do. Fantastic sentence. I checked up the previous Companies Act 1956 and 1813, like that, about 200 years back, the Companies Act I checked up. Word to word, they have retained Britishers drafting. What are the powers of the board? Not quantified. If you go deep into that, whatever a company, if it was a physical person, can do, the board can do on behalf of the company. Like that, you must understand. Look at the objects clause of the company. Yes, we can do all this. We can exercise these powers. So a company does not have hands, legs, brain of its own. The hands, legs, and brain of the company is the board of directors collectively. One sentence over. And from this, what do you understand? Board powers are not quantified. Nowhere he told in the Companies Act that 1, 2, 3, 4, 5, 6, these are the powers of the board, not required also. Once it so happened some 20 years back, one professional organization, I'm not giving any details, one professional organization, someone has set the paper and that paper came to me for expert evaluation. The person who set the paper, first question was, she used some wonderful frames, this, that, and all that, about 5, 6 sentences. And finally, the summary of that, what are the powers of the board? 16 marks question. I was flabbergasted looking at this question. I called that lady. I said, madam, what the student will write answer for this? Sir, powers of the board, where it is given in the Companies Act, what are the powers of the board? You know what the student will write? Power to purchase sofa set, power to purchase machine, power to purchase Jeraman, power to purchase a door, power to purchase the calculator. Stupidity. See, I always believed it. Unless you have absolute command and control of the subject, you must not become a faculty and play with the CA students at all. You must have complete control, command over the subject. You must read. The other day, Ganesh Balakrishnan told you, per day, please take Companies Act or some other topic, 1 hour, 2 hours. Once you become chartered accountant, it is not the end of the story. It is the starting point of the story. Knowledge is power. Money is not power. After that, I think she ran away from the Twin Cities. So coming back, board powers are not quantified. Board can do anything and everything which the company can do. So in simplified method, board can do. Board powers are not quantified. However, the second paragraph says, the board shall not exercise any power, do or anything, whether the act, memorandum, articles be exercised or done in general meeting. Beautiful. In the next point, he says, Mr. Board of Directors, I have given some powers to the shareholders. You don't exercise these powers. But when it comes to powers given to the shareholders, where it is given in this act, in the memorandum, and in the articles. So shareholders' powers are quantified. While board powers are not quantified, shareholders' powers are quantified at these places. Now you get a doubt. Sir, collaboration agreement to be entered. The value of the collaboration agreement is 250 crores. I think general meeting approval, don't think. What is the law saying? If you say general meeting has to approve it, show me. Show me in the Companies Act, show me in the memorandum, show me in the articles where the power will be exercised. If it is not there, who will exercise the power? Board will exercise the power. Beautiful. So there is no confusion between board powers and shareholders' powers. What are not the powers of shareholders are the powers of the board of directors. So if you say board shareholders' powers, show me in the Companies Act 34 ordinary resolutions, 38 special resolutions. Then in the memorandum, the article, show me. Then they are shareholders' powers. What are not the shareholders' powers? will become the board powers. So board powers are not quantified. The second limitation the powers of the board is, in exercising such power or doing such act or thing, the board, subject to the provisions contained in this behalf memorandum articles, not inconsistent. In the second limitation, he says, unlike in first limitation where I transferred the powers to general meeting, here I have not transferred the powers to anyone. I have put some inherent limitations in your otherwise free exercise of powers. Please follow that. I'll give some examples. These are all the inherent limitations. Somewhere in the Companies Act, he said, certain decisions are taken only at the board meeting, not resolution by circulation. This is nothing but a limitation on the power of the board. Please follow. Second, certain resolutions are to be passed unanimously. This is second limitation. Please follow. Certain powers should be exercised by the board only with the approval of shareholders in general meeting. Please follow. Certain powers to be exercised only after obtaining the approval of the tribunal, court, RD, ROC. Please follow. So two types of limitations in the powers. Otherwise, board can exercise free powers. One is some powers are given to shareholders, don't exercise. Certain things, I'm not transferred the powers to anything. I put an inherent limitation in your free exercise of powers. Please follow this. Then, what is this sentence? Or in any regulation not inconsistent therewith, duly made thereunder, including regulations in general meeting. Please see. Can the shareholders give a direction interfering with the powers of the board? I'll take one example. The board of directors today took a decision to give special discount of 20%. Shareholders are very upset. 20% special discount means 20% of turnover. Your profits is gone. Probably shareholders said, I wanted the board to sell, but if you give this kind of special discount, it will be sold. There is no need to sell. So what the shareholders did, they convened the extraordinary general meeting and they passed a resolution superseding the decision of the board. Resolved that in supersession of the decision of the board, the special discount be withdrawn immediately, and wherever possible in credit transaction, the special discount not availed shall be recovered. Can you pass a resolution like this? If you say yes, then it will break the very presumption with which I started the topic. What is the presumption I said? The presumption I said is board powers are different, shareholders' powers are different. Once the powers are given to board, shareholders cannot interfere. Then what does it mean? It means, yes, shareholders can interfere with the powers of the board consistent with the articles. That means what? There must be specific provision in the articles enabling the members to interfere with the decision of the board. It must be written, for example, in my given example, in the articles, it must be given discount policy. The discount policy shall be made out by the board of directors. However, the shareholders have power to increase or decrease the rate of discount. Like that, specific power must be there, not general power. Then consistent with the power, they can interfere. That is the meaning of this. Otherwise, they cannot interfere. So, practically, let me tell you, I have never found all this in the articles. Dividend policy, discount policy, pricing policy, the board can decide, shareholders can interfere. If you give all this in the articles, what the board will say, shareholders, you please run the company. Why the hell you appointed? So practically all that is not possible. So come back to the story. If the shareholders are not happy with the decisions of the board, what is the only one option available? One option available is you remove the directors, you yourself become the director and interfere. That is the meaning. So the division of powers. And one more issue, no regulation shall invalidate the prior act of the board. That means what? Even this power of the shareholders to interfere with the decisions of the board is in respect of future acts of the board. So in my given example, wherever possible, the special discount may be recovered is wrong. So this is how they have discussed beautifully the powers between board and shareholders, which applies to private company also. So certain powers are to be done only at the board meeting. You have to understand this very carefully. No resolution by circulation means let them sit across the table and discuss. These are mostly financial areas, power to make calls, buyback, Power to issue debentures, borrow money, invest the funds, make loans, guarantee securities, approve financial statement, diversify, amalgamation, takeovers and all. So these are powers which to be done at board meeting, no resolution by circulation. Then in the rules also they said political contributions, appointment and removal of KMP, internal auditor, secretarial auditor should be done at board meeting. Appoint and remove KMP, CFO, company secretary, all that MD cannot appoint. The matter has to go to board. Board meeting, it has to be approved. No resolution by circulation. For removal of CFO, removal of company secretary, MD cannot remove. The matter has to go to the board. Removal of the MD, all these people, matter has to go to the board. And at board meeting, they have to discuss the pros and cons and take a decision. These things has to be done only at the board meeting. Delegation of powers, another issue. Very interesting point. Out of all these powers, if the basic decision is taken in respect of three things, things can be delegated. For example, borrowing powers. The board may say, resolve that approval of the company B&D is hereby accorded to the managing director to borrow working capital from State Bank of India, Hyderabad branch to the extent of 35 crores. That's all. Further things can be delegated. Means what? How much is the cash credit will borrow? How much is the overdraft? How much is the bill discounting? Then what is the security will offer? What are the terms and conditions of the loan? You can delegate it. Similarly, investing the funds. Basic decision if you have taken, MD can take a decision, which company you can invest at what price, things like that. Similarly, loans. Rest of the items cannot be delegated, which means this I wanted you to observe. The rest cannot be delegated means, come back to the list, power to make calls cannot be delegated. That means the board has to decide everything. What is the amount of call? What is the last date for payment of call? In which shares they are paid? What is the interest payable? Approval of call notice? You get it? That's why call resolution is so complicated. Power to authorize buyback, nothing can be delegated. So how much is the amount of buyback? Last date of buyback? What is the method by which you can do buyback? Everything has to be covered in the board resolution. You understand? Only the next three can be delegated. Then these cannot be delegated. See, merger, amalgamation, approval of financial statements. Each and every point has to be discussed in the board. Then come to his appointment and removal of KMP cannot be delegated. Everything has to go to board level. That's why resolutions become quite complicated. And if you delegate, you can give it to committee of the board managing director and all that. Opening of a bank account, the banker insists on a resolution because it comes under this. It is board has to take a decision. It is equivalent to giving a loan to the bank. So these are all some of the points there. Contribution to charitable funds, charitable institutions. See, the board has to can contribute to charitable and other funds up to 5% of the average net profits for the preceding 3 financial years. So if there's a loss, you forget. Don't use negative also in the calculation. The last 3 years, 5% board can give to donations. More than that requires ordinary resolution in the general meeting. Charitable funds. Next, political contributions. Government companies and companies in incorporation less than 3 years cannot make political contributions. Why less than 3 years they cannot make? Because sometimes black money will be infused, and to start only companies for political donation, they may start. So government companies obviously cannot do. And the saddest part of the story is no limits. Notwithstanding anything contained in the act, a company can contribute any amount directly or indirectly to political party, because politicians only frame the legislation. Anyway, I don't want to comment more on that. Any amount you can contribute, whether you make profit or not. Then, only thing, this is in addition, because notwithstanding. So there are first contribution, what we saw, corporate social responsibility, 2% of net profit. Second one we saw, charitable and other funds up to 5% board, more than that any amount, shareholders approval. Third contribution is donations to political parties, any amount. So this is a different one. It overrides the other sections. Then the resolution should be passed at the meeting and justification law. No resolution by circulation. Board has to sit across the table. The resolution itself is justification in law, means Reasons need not be given. Why I am giving to them, why I am not giving to them, reasons need not be given. Once you pass a resolution, that is the end of the story. And you must see, these are small things. When they give it to a political party, the company should disclose in the P&L account separately, not mix up in the head. General donations or something, donation to so-and-so political party, which political party, what is the amount, all those details are to be given in the P&L account or notes on accounts. The auditor has to verify this. Then, notwithstanding anything, no donation can be made in cash. It should be done only through check or account pay or electronic NIFT and all that. Then, punishment C. The company will be punished a fine 5 times, and every option default 6 months imprisonment and fine. Look at the fun. The giver is punished. The receiver, stupid fellow, the political party is not punished. Don't ask me details. Next, donation to National Defense Fund. This is 4th defense. This also any amount you can contribute. No board resolution, nothing. Board or any person, MD himself can take a decision. You have to disclose in the P&L account. This also not study. So even in a private company, 4 types of donations can be given. CSR donations, then charitable fund donations, then donations to political parties, donations to National Defense Fund. We will now move on to loans 185 and 186. I'll spend a lot of time on that. 185. Please understand the structure of 185 and 186. I'm very sorry to say, except for few chartered accountants or even company secretaries, once they are qualified, their in-depth knowledge in these sections are totally lacking. 185, 186 loans, 2 sections. 186 is basically a prohibitory section. You cannot give loans, guarantees, and securities to these peoples and institutions. Of course, 185 does not talk of any procedure. 185 doesn't talk of procedure. 186 talks of procedure. So what you should sink your mind is, if you are not permitted under 185, don't look at 186. If you are permitted under 185, then the procedure under 186 has to be followed. Now, before I start into this, first let me make a comment. Loans, guarantees, and securities to the directors and the people connected with the directors per se is bad. Why? The shareholders, debenture holder, deposit holders, banks, financial institutions, creditors, and other people have pumped money into the company not to enable the directors to give loans to these people. Given a free choice, I would like to see my money in the form of fixed assets and current assets minus loan. So, loan should be an exception rather than routine. Let's start. Loan. What is a loan is not unfortunately defined. However, the Supreme Court made a judgment. Loan, while giving, you can give cash or in kind to another person called borrower, and there must be recognition of liability on their part to repay. While repaying, they should repay in cash, with or without interest. Interest is not the deciding factor. I repeat again, beautifully they tried to define, while giving, you give cash or even kind, money or even goods to another person, and there's a recognition of liability to return that. While returning, you should return in cash with or without interest. Even without interest, it comes under loan. Guarantees and securities are also covered. If they are not covered, what will happen? Very simple. The director will take a money from a third party guaranteed by the company, and that fellow will not pay, and the company has to pay. So guarantees and securities given by the company is also covered. Guarantee, what is the difference between these two? Guarantee is not supported by mortgage. Only some promissory note, bill of exchange, post-dated checks, undertaking given by the company. These are guarantee. Security is a guarantee supported by mortgage of assets. So come back. The section covers guarantee, security, and loans. First part of the story. No company shall give directly or indirectly any loan, guarantee or security to all this organization. Prohibitory section. Step by step, let us read. I'll come to private companies slightly later. These are nothing but diversion of fund. Prohibitory section. Central government also cannot allow. Shareholders also cannot allow. Prohibitory section. To whom? Let me analyze all this. First, director of the lending company or its holding company. Understand the implication. Suppose, let us say, let's take one example. Nagarjuna Fertilizers Chemicals Limited is the lending company. There is also a holding company, Nagarjuna Holdings Limited. Now, how many directors? Nagarjuna Fertilizers, 12 directors, Nagarjuna Holding, 13 directors. So set in your mind 25 directors. The flagship company, Nagarjuna Fertilizer, if they give a loan to any of its 12 directors or any of the 13 directors of the holding company, it is ought to be covered. If it is not there, what will happen? The director of the company will put the influence on the subsidiary company and take the money. But loan guarantees and securities given by the company to its subsidiary is not covered. So 25 directors. Next, relative of such a director. Relative of such a director. Relative of 25 directors. On the day we spend time trying to understand who is the relative. So once again, quickly looking at it, this is the relative, father, mother, brother, sister. This is the relative. So how many relatives a person has? Not the 7 or 8. You have only one brother, one sister. Except for the present generation, previous generation, except for the present and the previous generation, now only we have restricted our production. Otherwise, the full cricket teams only was there in India. N.T. Ramarao had a complete 12 children, 11 children he had. Then he forgot to produce the 12th man. He had the 12th children also. That's why cricket became very popular in the country, you know, lot of cricket teams. So if you have 3-4 brothers, then 2-3 children, their spouses, my experience tells me handling all these business people, on an average, each fellow has got 30 relatives. Just see the figures. So how many relatives? 750 people are relatives. Please maintain a list. Prohibitory section. Relative of such director. The story doesn't end there. Partner of such a director. Partner of such a director. I am a director in Nagarjuna Fertilizer. I am also partner in Jairam Radhakrishna Associates. Nagarjuna Fertilizer is not giving to Jairam and Radhakrishna Associates. They are not giving to firm. They are giving to Radhakrishna. Understand the implication. Let me put some figures. Please see. Just now I told you total 25 directors. Total relatives how much? 750. Right. Now each director, let us say, they are business people. They are partnered in 4 partnership firms. So how many partnership firms are involved? 4 into 25, 100 partnership firms. Now let us say in each partnership firm, other than this person, let us say there are 5 partners. So how many partners are involved? 500 partners are involved. Keep the list. Keep the list. Are we doing as chartered accountants? And these things can be done only at coaching. I'm not joking. We must have a special software to catch all this. This is the exact story in this Satyam Computers case. It is there, this section. So, relative of such a director. Next one. To the firm in which such a director or relative is a partner. I am a director in NFCL. I am a partner in Jairam and Radhakrishna Associates. NFCL gives a loan to JRK Associates. Will attract. Just now we saw how many partnership firms are involved. 100 partnership firms are involved. Adhikadaya, what is he saying? Loan to a firm in which such a director is a partner, he did not say. Loan to a firm in which such director or relative is a partner. Understand the implication. Now 25 directors, relatives 750, then partnership forms 100. Now, total partners of the directors 500. Right. Each relative has 4 partnership firms, 750 relatives. So how many partnership firms? 3,000 partnership firms. Loan to a firm in which such a director or relative is a partner. That's all. Prohibitory. Are we maintaining all this list? 25 directors list, 750 relatives, partnership firms of the directors, 100 partnership firms, total partners of the directors 500, partnership firms of relatives 3,000. Are we maintaining all this? Are we maintaining all this? So this is the issue. Right, next. Now, these are all the big list which I made out. Prohibitory section. You cannot give any loans, guarantees, and securities to all these people. The second part of the story. The second part of the story is, in these 3 cases, you can give loan, guarantee, or security only by passing special resolution. And the special resolution don't blindly pass. Explanatory statement must give all the details. Let the shareholders involve themselves in informed decision making. Then the loans must be used only for principal business activities. Who are these people? To a private company in which such a director is a director or member. Loan to a private company in which such a director is a director or member. Now, let's start looking at the figures. Let's start. Let us say, I am also a director here. I am also a director or member of some private company. I am also a director or member of some private company. Let us say about 10 private companies, each director. So how many private companies are involved? 25 directors into 10, 250 private companies are involved. Please see, I am a director in Nagarjuna Fertilizers Chemicals Limited. I am also a member holding 100 shares in Maheshwara Computer Software. If they give prohibited, if they give prior special resolution is required. Then loan to a body corporate in which 25% or more of voting rights is exercised by one or more such directors. He didn't say public company, body corporate. What is body corporate? Public company, private company, statutory corporation set up under a separate act of parliament or state legislature, and then foreign companies. Reliance Industries Limited giving a loan to Sony Corporation of Japan requires special resolution if Mukesh Ambani and other directors are holding 25% of the shares in Sony Corporation of Japan. So Reliance Industries giving a loan to ICICI Bank Limited will attract the section if the directors are holding 25% of the voting power in ICICI Bank Limited. Body corporate, then special resolution. Last one, to any body corporate which is in which the board MD manager is accustomed to act in accordance with the directions or instructions of the board or director of the lending company. Masterpiece drafting. I'll explain this. Let us take the example. I worked in Rasi Group for about 1 year, about 30 years back for experience. This is what the other day Ganesh was also telling. This is my famous example which I give. B.V. Raju, the kingpin. Now let me start. Rasi Cements Limited, the flagship company, B.V. Raju was chairman managing director, and 51% of the shares was held by him or his relatives also. If I say B.V. Raju controls Rasi Cements Limited, fine, because he's the chairman MD, 51%. Let me come to second company, Rasi Ceramics Limited. In Rasi Ceramics, B.V. Raju is only a director and he holds 25%. Okay, director and 25%, still I can say B.V. Raju controls Rasi Ceramics. Third, in Rasi Refractories Group Company, B.V. Raju is not a director, he just holds 10% of the shares. Though some people may not agree, still I can say B.V. Raju controls Rasi Refractories Limited. Now the climax. In Rasi Finance Limited, BV Raju is not a director, is not holding any shares. If I say BV Raju controls, it is senseless. He's not a director, he's not holding the shares. This is theory. Practically what happens? Practically what happens in that multi-storied building of Rasi, about 8 floors, BV Raju sits in the top floor. The managing director of Rasi Finance Limited, all dummy. He goes, touches the feet of BV Raju, and in Rasi Finance Limited, right from approval of tea bill of 2 rupees, those days tea cost was 2 rupees, right from approval of phenyl and other washing materials, right from recruitment of office boy to finance investment decision, BV Raju only takes. Then what is this control? How the control is exercised is not the issue. Whether the control is exercised or not. Now say, Rasi Cements Limited, the flagship company, gives a loan to Rasi Finance, it will attract special resolution. Come to the point. Loan to a body corporate, Rasi Finance Limited, in which the board MD manager has defined accustomed to act. Why is acting? We don't know. It all depends on facts of the case. Accustomed to act in accordance with the directions and instructions of board or director BV Raju of the lending company Rasi Cements Limited. Now extend this philosophy. In Reliance Industries, Reliance Group, Mukesh Ambani Group, there are 86 companies, group companies, directly or indirectly connected with each other. Mukesh Ambani is not a director in all the 86 companies. In about 10 companies, he is a director. But then, let us say, Reliance Real Estate Private Limited, 86th company. If the flagship company, Reliance Industries Limited, gives a loan to Reliance Real Estate Private Limited, it will attract. Because you are giving a loan to Reliance Real Estate Private Limited, the body corporate, in which the board MD or manager accustomed to act. They'll prove. How you will prove depends on facts of the case. If Mukesh Ambani comes, everyone will stand. Now come back. So these group companies, if they give loans to any of these companies, it will attract the section, special resolution is required. So first 4 cases, prohibitory. Next 3 cases, special resolution is required. Next. No company shall directly or indirectly. Why did he use the word indirectly? Indirectly covers what? Suppose I give a loan to a trust in which the director is a trustee or beneficiary or HUF. No, it will not attract indirectly. Very clearly, you have to give a loan to the director, relative, partner, firm, private company, body corporate. So this cannot stretch the word indirectly. Next, will it attract quasi-loan? What is a quasi-loan? Look at this. The company gives a loan to Mr. A. Who has to return back the money? Mr. A has to return back the money. A doesn't return back the money. One of these 5 persons, they are returning back the money. Means what? The money might have been transferred to the director. So he is returning. The department said, no, it will not attract. Because there may be genuine debtor-creditor relationship. So it will not come under the word indirectly. Then indirectly means what? Agents. So if the company gives a loan to an agent of the director, agent of the partner, agent of private company, it will attract. Next, look at these 4 situations. The company gives a guarantee or security. This comes in guarantee and security to specified person, means this 4 plus 3, 7 parameters. The company gives a loan to a director, gives a guarantee to a director to enable the director to give a loan to another director, specified person. Another combination. Company gives a guarantee to some person, not connected to the 7 parameters, to enable them to give a loan to specified person. Then loan to a specified person to that. In this, which it will attract? First 3 will attract. I'll give an example. Come to the second point. Reliance Industries Limited managing director went to LIC Housing Finance for a loan of 10 crores to construct a building. LIC Housing Finance gave the loan but put a condition the company in which you are a managing director must give a guarantee. Now come to the second point. Company, Reliance Industries Limited, gives a guarantee to some person. Who is that person? LIC Housing Finance, to enable the LIC Housing Finance to give a loan to Mukesh Ambani came. So first three cases will attract. Last one, person to person, it would not attract. Then supply of goods on credit to a director, will it attract? Listen very carefully. These are all department clarification. See, what is the definition of loan? You are at least coming under the definition, isn't it? How? You are giving goods to the director. He is keeping it for some time. Then he is returned back. And while returning back, he is returning the money. Am I clear? So it is coming within the definition of loan. Now, the department came with a point. The department came with the answer that it all depends on facts of the case. You don't take a yes stand, don't take a no stand. For example, let us say that fellow was a dealer. That fellow was a dealer for the last, let us say, 10 years. Yes, he was a dealer. So how much credit was given like any other dealer? Let us say he was given a credit of 10 lakhs. Then next one, how much of credit period? 1 month. What is the rate of interest? 18%. Yes, now he became a director. Are you giving on the same terms? Yes, sir. It will not attract the section. On the other hand, you made a dealer just because to avoid this, and you gave some, normally other dealers you are giving 5 lakhs credit, you gave him 10 lakhs credit. Other people you gave 1 month credit, you gave 3 months credit here. It will definitely attract the section. Then, traveling advance, conveyance advance, very important, please see. All the chartered accountants take a stand. When you give a traveling advance to the director or relative, all this, particularly director, let us say, it will not attract the section. Hurry, we are giving traveling advance. Department says, look at the facts of the case. If you say it will not attract the section, a smart managing director, what he will do, whenever he wants some money, he will take money, 10,000 or 20,000 or 25,000 and book traveling advance, the smart finance manager. And he will rotate the money for 1 month, 2 months, and he will return back. Then they'll credit the traveling advance account. You have to be very careful. Once or twice the traveling expense can be credited, not every time. See, all this case law, these all the answers were given in this MR Electronics Components Limited case. In this case, the MD's wife was appointed as, MD's wife was given a salary advance of 5,000. Old case. The matter went to High Court. The High Court said, just because she happened to be a relative of the director cannot justify the offense was committed. You have to prove before me that this transaction is a sham or cover-up. The High Court said, one, okay. You ROC first find out, is she genuinely an employee of the company or she was made an employee only to receive the salary advance? No, sir, she was an employee for the last 15 years. Very good. Second, is there a scheme of salary advance in the company or exception was made to her? No, no, sir, there is a scheme of salary advance. Third, what is the amount of salary advance given? The usual 1 month, 2 month salary or 25 times the salary? No, no, sir, 1 month salary. Good. Third, what is the usual terms of recovery? The 10 installments or the 250 installments, sir, the 10 installments? Then the court said, you donkey monkey. As simple as that. Every payment will not attract the section. You find out in each and every case whether it's a genuine salary advance, traveling advance, conveyance advance, or loan disguised as these. That's it. You got an answer. You got an answer. Because advance also has the characteristics of a loan. Then similarly, all this I told you, rental advance, it will not attract the section. See, nowadays, the MD was given as a part of remuneration package, free rental accommodation. Since the company did not have the quarters of their own, they took one house on lease and they had to pay rental advance to the director. Payment of rental advance to the landlord, will it attract this advance given to the MD? No. For 4 reasons, they said. One, the company has not given to MD. Landlord is not the relative of the MD. So second one they said, it is usual practice to give security deposit. Then third one, it is the contract is only between the company and landlord. MD is not bothered. You beg, borrow, or steal. I am not bothered. And fourth, it is a usual business transaction. There's nothing wrong. And anytime you can cancel the contract. So these things will not attract. Then loan and deposit. Okay, you will not call as a loan. You will call as a deposit. There's technical difference. The Act says no difference. The department says you call it as a deposit also, it will attract the clause. Then loan and debt. See, suppose the MD is sold one flat, one of the director is sold one flat, or relative of a director and all. They are sold the flat. Now it comes within the definition of loan, isn't it? While giving, you are giving the goods, you are giving the immovable property. Then they will return over a period of time. But then they said, it will not attract the clause because the idea is you give a flat, you sell it, he'll return back the money in installments. It will not attract the clause because the liability to return the money should arise out of a loan transaction. Here, the liability to return the money is arising out of a sale, debt transaction. So it will not attract the clause. Then they said exceptions in 185. 1. If you give a loan guarantee security to MD and whole-time director, not ordinary directors, because one is you give traveling advance, all these loans you can give as a part of conditional service extended to all employees. President, vice president, chief CEO, all these top people get a lot of loans. Why do you deprive the MD? You can give them. Or if you are not giving it to all, by pursuance to special resolution, you can give them exempted. Then one is for the finance companies, investment companies in the ordinary course of business. Yes, what is wrong? They are doing finance business. So give it to the director and all. But rate of interest should not be less than the government security rate of interest. You give it to them. Third, loans, guarantees, securities made by holding to wholly owned subsidiary are exempt. Why? Hey, I have already declared to the outside world, it's a subsidiary company. The financial health of the subsidiary is a direct concern for the holding company. So it's a direct concern for the holding company. Therefore, if something is wrong with the subsidiary, if the holding company cannot come to the rescue, who will come? So by no stretch of imagination, we'll call it as diversion of funds, exempted. Fourth, guarantees and securities provided by holding company in respect of loans by bank financial institution to subsidiary is exempt. See, usually what happens when the subsidiary company goes to a bank or financial institution and takes a loan, subsidiary company goes to a bank or financial institution and takes a loan, the bank will ask the holding company to give a guarantee. They are all exempt because this is a matter of routine. Then consequence of violation, see, company 5 lakhs to 25 lakhs, officer in default, 6 months imprisonment, 5 lakhs to 25 lakhs, all this come to private company. Now 185 is not exempt to all private companies. 185 is exempt to only these private companies if you comply with the 3 conditions. Whose share capital no other body corporate has invested. Means what? All the shareholders of the private company are individuals. Second, the borrowings from banks, financial institution is less than twice the paid up capital or 50 crores, whichever is less. Your debt equity does not exceed 2:1 and the company has not defaulted. So these private companies, if you comply, then the section will not apply. Means what? You can give. You can give loans to directors, relative, partner and all. And for the next 3 cases also, special resolution is not required. Like that, you must understand. But very few companies come in the category. All other private companies also, this section will apply. First 4 prohibited, next 3 special resolution. Subsequent applicability. The applicability has to be seen as on the date of transaction. For example, when I gave a loan to the company secretary, not covered. But during the substance of the loan, the company secretary became the director. No, it will not attract. Similarly, a private company was converted into public company. It will not attract, right? Then, now please we'll go to the next area of discussion. Now please listen. See, there are some participants raising hands. I cannot reply to them. My flow will be affected. I told them my telephone number is available. You can send email or SMS. I will answer them. So please don't disturb the flow in which I am in. I have got very limited time in which the entire Companies Act I have to cover. Right. Loans and investments by the company section, let us say 186. Now, first, let us understand 185, 186 properly. 185 does not talk of procedure except that special resolution. 185 only says whether loans, guarantees, securities can be given or not. If is permitted, look into 186 procedure. If it is prohibited, don't look into 186 at all. That means, now just now we saw private companies which are complied with all these conditions, permitted. Permitted means procedures in 186 you have to follow. Similarly, managing director, holding to subsidiary company, they're all permitted. Means procedure in 186 you have to follow. Now you get it. What is the procedure you have to follow? Loans and investments by the company. Now look at this point very clearly. The board of directors themselves can give loans, guarantees, securities, investments to any person or body corporate up to 60% of paid up capital free reserves, securities premium, or 100% of free reserves, whichever is more. More than this, prior special resolution is required. More than this, prior special resolution is required. This is the sum and substance of section 186. 60% of paid up capital free reserves, too much, isn't it? Paid up capital is 100 crores, free reserves 100 crores, 200 crores, 60%, 120 crores. Board themselves can divert. So he is giving quite a lot of figures. And more than that also, just shareholders prior special resolution is required. 100% of free reserves is fair. What is free reserves? Undistributed profits belonging to equity shareholders. So that you can divert, no issue. But 60% is terrible. So come back, what is he saying? You can give loan, guarantees, securities, and investments up to 60% of paid up free reserves, 100% of free reserves, whichever is higher. Board, more than that, prior special resolution is required. One more point I want all of you to observe is, the heading is not intercorporate loans and investment, which was then the previous Companies Act 372A. The heading is loans and investments by company. You should observe A Limited giving a loan, guarantee or security to investment to a body corporate alone is not covered. To any person, Mr. A, Mr. B, Mr. C, Yallaya, Mallaya, Pullaya, you give 100 rupees, it is covered in this section now. I don't want diversion of funds. 100 rupees, the company is giving a loan to Mr. A, matters to go to the board, meeting of the board. How many of you are following this? Even in private company, if you are not, even in private company, if you are exempt also, this procedure has to be followed. You have to follow this procedure. To any person, loan, guarantee, security to any person, investment to a person or body corporate, investment only to body corporate. Then the special resolution has to give the outer limit. The giver should be a company, receiver can be a body corporate. So the company, private or public company, gives a loan, guarantee, security to any person or private company, public company, statutory corporation, foreign company, will attract the section. Then one limit control means there is no separate inner limits for loan, guarantees, securities and all. So what we normally do, every time we take all the giving under that 60%, 100% control, including the loans guarantees given, already given, will also take into the calculation. Then loan, does it include deposit and debentures? In the older Companies Act, is specifically excluded it. Sorry, specifically included. But in the new Companies Act, there is no clarity. In the absence of clarity from the department, even this will come. So now please see the company giving a loan, guarantee, security, investments, in debentures, deposits, everything is covered in the calculation. Then acquisition of securities of body corporate. Now please see this point very carefully. I'll raise some 4 questions. 1. Reliance Industries Limited investing in ADR, GDR of Sony Corporation, will it attract the section? 2. Reliance Industries Limited putting the money in master share in UTI, will it attract the section? 3rd, Reliance Industries Limited putting the money in Kotari Mutual Fund, will it attract? 4th, Reliance putting the money in government securities, will it attract? To answer this, the 3 words we must see. Acquisition. Acquisition means directly subscribing or purchasing. Second, securities, use the word, not shares. So it will cover equity shares, preference shares, mutual funds, bonds, government securities, everything. Then to whom? Body corporate. It didn't say company, public company, private company, foreign company, statutory corporation. Come to my first point. 1. Reliance putting the money in ADR, GDR of Sony Corporation will attract. ADR, GDR is security, then body corporate, Sony Corporation. Second, Reliance putting the money in master share of UTI will attract. Master share is a security, UTI is a body corporate. Third, Reliance putting the money in Kotari Mutual Fund will attract. If Kotari Mutual Fund is set up as a company under the Companies Act, not as a trust. Fourth, Reliance putting the money in government securities, even though government securities come under the definition of security, government is not a body corporate, so it won't attract. Like this, you must understand. So security has all the meaning. Next, 60% of paid-up capital and free reserves. So what are all the free reserves? Just P&L account, credit balance, general reserve, dividend equalization, share premium. He has to add securities premium. So these you should not take in the calculations. Capital redemption reserve, sinking fund, provisions, revaluation reserve, capital reserve, whatever be your accounting standards and all, this is told very clearly in the Act. So these things cannot be treated as free reserves. Next, disclosure in the financial statement. While he has opened up the figures, hell a lot of procedures you have to follow. So disclosure in the financial statements. So in the P&L account balance sheet, you must give complete details. The loans, guarantee, security, investment, whom it is made, purpose, and other details. Every individual loan guarantee you have to give. Then board meeting, unanimous approval. No investments, land guarantee, security can be given unless the resolution is passed at meeting of the board with the consent of all the directors present. Prior approval of public financial institution subsisting is obtained. Now see, however, prior financial institution is not required if it does not exceed the 60% and no default on the repayment. Now please see. Understand what is he saying. Every loan guarantee, security, investments has to go to the board. MD cannot take a decision. 100 rupees given to Mr. A. Matter has to go to the board. No resolution by circulation, no MD. Meeting of the board. Now the climax. Unanimous approval of all the directors present at the meeting. If there are 12 directors, one director vetoed the proposal, gone. This is what I was telling you in Satyam Computers, what has happened. There were more than 12, 13, 14 company secretaries, chartered accountants. No one has seen this. 400, 500 cases of loans, guarantee, security never came to the board at all. What kind of management administration we are doing? You have to see all this as the statutory auditor and internal auditor. Even in private company, we are the impression that nothing applies, nothing applies, nothing applies and all that. Matters go to the board, meeting of the board, consent of all the directors present. Story is not over. If you have taken loans from public financial institution, their approval is required. Now, please see public financial institution, 4 different positions. You are giving loan guarantees up to 60%. And what is the default in the public financial institution? No default. Like that, 4 options. You mean to say public financial institution will give you approval? Even if you are prompt in the repayment of loan, he won't give the approval because they follow conservative policies. They will not give you approval. You get it? Because the debt service coverage ratio and all will be affected. Now, 3rd and 4th cases, will they give approval? Forget it. You are defaulted their payment and they give approval for giving loans to Intercorporate and others. Second one also, they will not give approval because even though you are prompt, but the loans are exceeding 60%. So if at all the financial institution give the approval, they will give only the first case. The government knows this. So they said, in the first case, if your loan is up to 60% no default, no approval is required. So while they allowed you to make 60%, hell a lot of procedural restrictions are given. Every proposal has to go to the board, meeting of the board, unanimous approval of all the directors present, financial institution approval must be taken. My God. Special resolution not required in case you give the loan from holding to only one subsidiary. Now come back. In 185, I said exempted, that means permitted. But the procedure in 186 has to be followed. And in what is the exemption given 186? Only special resolution is not required. But other points has to be followed by the holding company, meeting of the board, unanimous approval, financial statements, all those details have to be given. Then rate of interest. See, there is something called cost of funds for a company, isn't it? Average cost of funding. Equity shares, preference shares, you pay dividends, then term loans, working capital, all that you have to pay interest. Average cost of fund comes to say 12% to 15% or even 16%. Now you give intercorporate loans and all at 3%, 4%. Ridiculous. So what they said, the rate of interest which you give should not be less than the government security rate of interest. Previously it was bank rate of interest. Now they say government security rate of interest. Then default in the repayment of the deposits. What is that? You are taken some deposits which we discussed the other day, either from members or public, and you are defaulted. Why did you default? Cash problem. You have no cash to pay the deposit holders, but you have got all the money in the world to give intercorporate loans and other loans and investments. Stop that. Then you have to maintain one register in MVP, giving all these details, and should be authenticated by the board, and this open for inspection, all that. And this section will not apply to these companies who are all givers. Banking company, why? You are already regulated by the Banking Regulation Act. And your main function is banking business. Insurance company, they are regulated by IRIDA. Then housing finance company, they are regulated by National Housing Bank. Then finance companies, infrastructure companies, it won't apply. Investment companies, all that. Then right shares also, it will not apply. Because why right shares will not apply? See, Reliance Industries is giving rights. Nagarjuna Fertilizer is applying for rights. You have to pay some amount. Why board approval not required? Because that company will open the rights only for 30 days, within which you have to take board approval and all that. They're not possible. And please understand one point, rights per se is a benefit. When the market price is more, rights is given at a lower cost. So why you take board approval and all? Waste of time. Then exemption, some issue. Right. Consent cause contravention. See, 25,000 rupees, company is punished, 5 lakhs, officer in default, 2 years imprisonment, all those things. And power to make intercorporate loans cannot be delegated. So when you are giving all this, everything the board has to decide. Then one department clarification. Now look at this. First clarification, they said, special resolution for loans investment beyond the net worth should not be passed. What is the issue? Please see this example. Share capital like that, 600 crores. Now tell me, 60% of paid up capital free reserves comes to how much? 120 crores. Board themselves can give. More than 120 crores, special resolution is required. More than 120 crores, how much? One stupid fellow said, sir, complete 600 crores will give. Department said, hey, cheating. While the department did not write the language properly in the act, department now says there's an outer limit. Net worth means what? 200 crores only you can give in the given example. That means what is the meaning? Borrowed funds cannot be used for intercorporate loans and other loans. Secured loans, unsecured, current liabilities, they cannot be used. So there is an outer limit. So this is the first clarification they gave, borrowed funds. Then explanatory statement, should en bloc resolution should be avoided. Very interesting. See, when the shareholders give the approval, company-wise, investment-wise, they have to give the approval. No en bloc approval. For example, because as a shareholder, I may like my company investing in Reliance, not investing in Nagarjuna Fertilizer. So when you get that 60% approval, company-wise, investment-wise, Reliance Industries, convertible debenture, separate approval. Investing in Reliance Industries, preference share, separate approval. Like that, you have to take the approval. This is the department clarification. An investment should not exceed 2 layers. A can invest in B Limited to C Limited. C to D will not be permitted. Next, loans to employees and all. Now, I told you loan to any person, obviously it includes employee. So loans to employees are only for the benefit of the company. So in the definition of person, they excluded employees. So if you are giving loans, guarantees, securities to the employees and all, it is permitted. No procedure of 186 need to be followed. And now look at the procedure. First, the matter has to go to board. Meeting of the board, no resolution by circulation. Consent of all the directors you must take. Then convene the EGM if it exceeds the limit. The notice should give the necessary details. Special resolution has to be passed. MGT 14 has to be filed with ROC. Then rate of interest should not be less than the government security rate of interest. If you have taken loans, public financial institution, their approval is to be taken. Then you have accepted deposits, no default in the repayment of deposits. Then update the register within 7 days. You have to give the details in the financial statements. That's all. So this much you must go through very, very carefully. So thank you very much. Thank you very much. Will I now request the chairman to give his concluding remarks.
So good evening and welcome back, and really excellent session on the directors, managerial remuneration, loans and advances and everything. Really a great value addition to our lecture. Thank you, sir. Thank you very much for enlightening us on the various topics. Friends, a small announcement regarding this public limited companies. We are going to conduct the part 3. Whatever the provisions that are applicable to the private limited companies in part 1 and part 2 are applicable to the public limited companies. In addition to that, we are taking another 3 sessions in the December, in 16th, 17th, 18th of December for the public limited company, as we should not conduct any of the programs from December 1st to 14th as per the instructions of SARC. That's why we are conducting on 16th, 17th and 18th. So I request each one of you to kindly attend for that also, so that the complete Companies Act will be on your fingertips. Thank you very much for the same. And now, without wasting much of the time, I'm calling off today's session. And tomorrow we'll exactly meet at 6 o'clock. And mind you that there is going to be maybe, with the permission of Jayaraman sir, maybe on the Friday also there is going to be another session.
Yes.
So with the consent of all your members, if it is acceptable to you all, we'll conduct one more session, because the pace at which sir is going on, it is not sufficient to cover all the parts of the part 2 of the private limited companies. That's why we thought of conducting one more bonus session on the Friday from 6 to 8 p.m. Thank you one and all.